So thank you for checking out the Contract Bank. I am business attorney Roxanne Smithers, and today I'm going to take you through another contract that we have in our bank, the Master Brand Development Agreement. That agreement is intended for individuals who are providing services to clients and customers to help them develop an awareness of their business and of their brand within the marketplace. That can include an awareness online, that can include other print media, that can include events and other types of advertising in order to make people aware of your customer or client services, their products, or their business in general. And so we've got a great master agreement that you can utilize. And we've prepared this as a master agreement so that you can use it for customers or clients who are going to be continuing with your services. You may have multiple scopes of work with those customers or clients. You may have projects over projects that you do for a client. This will provide you with one set of terms and conditions that can apply to each project or to each scope of work that you agree upon with your customer or your client. So let's get started. So once you look at the agreement, one of the first sections that are key and most important are going to be your fees and expenses. So this section is intended to make sure that it is clear how you're going to be paid and if you are going to be reimbursed for any cost or expenses above your standard rate that you may incur as part of providing these services to your customer or client. So that could be software, that could be subscriptions to certain online platforms, that could be access to certain events, databases, or other resources or assets that you need to employ or deploy in order to help your customer, your client build their brand awareness. The next section that we're going to talk about are how do you make changes to this agreement? As we understand, oftentimes in business, and particularly in developing a strategy for a customer to increase their brand awareness, you have to be flexible. You may need to pivot to different mediums, different parts of the marketplace, or take advantage of events that are outside of your control. So the agreement provides a process by which the parties can make changes to the scope of work or changes to the agreement in general. That's what Section 3 is going to cover. Next, we're going to look at Section 4, which details the responsibilities that you will take on in this relationship, as well as the services that you will provide. It provides an opportunity for client input on any deliverables that you make available as part of your process and gives a timeline by which the client needs to respond. And then that flows into Section 5, which covers the responsibilities of the client. So similar to you having responsibilities to make deliverables available, examples, lay out a plan or a strategy for your client or customer, your client or customer has a responsibility to provide you with accurate information, to provide you with information to which they have a right to utilize, and to also make sure that they're reviewing the deliverables and providing feedback to you. With that in mind, that flows into Section 6, which specifically talks about the process by which your customer or your client will approve any plans that you propose, any deliverables that you draft, or any other product of your services that you need their go or no go on before you implement the plan. Section 7 then answers the question as to who owns your great ideas, who owns the content of the deliverables that you may create for your client, who owns the content of the products that you're creating for your client. And so it deals with the intellectual property rights. The way the agreement is set up currently, you maintain the intellectual property rights until the point that you are paid in full for your services and for your deliverables. The client has an opportunity for a license to utilize those items, and only once you've been paid in full, are you then going to transfer those intellectual property rights to the customer or to the client. Section 8 discusses making sure that the parties are providing accurate information for the process. This is particularly important when it comes to both you relying on information from your customer or your client, as well as your customer or your client relying on information from you, relying upon your representation of your skills, timelines, and effects that you are expecting for the services that you are providing. And it does, in fact, put a limit on the warranty or on the promises that you're making for the effectiveness of your services. Because as we know, there are many variables that are beyond your control that are going to impact the effectiveness of the services that your client is seeking. And so we want to make sure it's very clear and limits your responsibility for variables that are outside of your control. Section 9 and 10 cover both the control over confidential information, but the sharing of information that you may provide in terms of your processes, your strategy, and information about how you provide services, as well as confidential information that you may receive from your client or customer about their business. Both parties are required to maintain the confidentiality of that information and keep those secrets for each other. 10 covers whether or not your customer can solicit any of your employees, staff, vendors, or independent contractors to leave working with you to work with them directly. And we've got a bar on them being able to do that. Section 10 covers the length of this agreement, i.e. the term of the agreement, as well as details how the agreement can be terminated by either party. This section also addresses what happens if the master agreement is terminated while you're still in the middle of performing under a specific scope of work. There are options to terminate just a scope of work or to terminate the entire agreement, and this section details what happens in the event that you also need to wrap up the work on a specific scope of work that's still outstanding. Section 12 and 13 go hand in hand. Section 12 is a limit on your liability. This means that in the unlikely event that there are problems with your performance, that there are any damages or injuries that your customer or client believes they have suffered, that there will be a cap on either the amount or the type of damages that you could be held responsible for. And then Section 13 covers how each party will indemnify the other party. That means protect them or reimburse them for any loss or damages that are incurred through the fault of the other party. For example, if your client gives you content that they want you to use in their brand awareness campaign, and it turns out that they did not have the proper license or the proper ownership of that content in order to utilize it, and you are subject to a trademark claim or action. Per Section 13, your client will be responsible for reimbursing you for those costs or expenses, or actually stepping into your shoes and resolving that trademark claim or that trademark action. Sections 14 and 15 detail and make it clear that you are an independent contractor, that both of you are free to work with other individuals. This is not an exclusive agreement where you are solely bound to this one customer or client. 16 and 17 cover what happens if there are issues and there is a dispute between the parties in the contract. We have the governing law, that's going to be the state where you're located, and then we have dispute resolution provisions, how the parties are going to resolve any claims that occur between them. Section 18 details how notice is given for any issues within the agreement, and 19, 20, and 21 are really interpretive provisions that really talk about if by chance a judge, a jury, or an arbiter has to look at the terms of this agreement and actually apply them to a dispute, how they would handle doing that. Finally, we also have your statement of work that can be utilized multiple times for multiple projects with the same customer. This is where you'll lay out the details of your scope of services, any specific deliverables that are part of what the client can expect from you, and a time frame for your performance in those deliverables. It lays out the specific way in which you will be paid, whether it's hourly, flat fee, provides an opportunity for you to require a retainer to require a retainer or a percentage of your flat fee up front to get started for the work, and tells when payments are due. You also have an opportunity in the scope of work to make any specific one-off modifications that you want to make to the terms and conditions that will only apply to that specific project or that specific scope of work. So that concludes my summary of our Master Brand Development Agreement. I want to thank you for checking out the Contract Bank, and as always, I am your business attorney, Roxanne Smithers.